Thank you so much. Thank you so much for the nice introduction and for inviting me over to Cambridge. It's always a pleasure coming here. I know that my first visit to Cambridge actually was a similar setting. At the time it was also a mixed audience. I believe I have a mixed audience today. I see several colleagues, so thanks for coming. And in terms of student participation, I think several of you are LLM students, undergraduates also. So whatever it is, I believe I'm talking about a subject that can easily be understood. So don't be afraid, even if you do not have specialist knowledge in the field of IP. That should be something we can discuss together even without that much of background information. And apart from that, I'm particularly interested in your views on the topic. So as far as I'm concerned, it would be great to have from the beginning a debate that is interactive and not just me entertaining you for hours and hours until you finally think, okay, I hope the guy stops at some point. The topic is, as Lionel has already indicated, keeping me busy for a while already, because it's also a bit of a personal thing. I started in intellectual property with a focus on copyright, and then later on, when I worked for the World Intellectual Property Organization for a while, I was in the trademarks department there. And learning about trademark law from a copyright perspective, I found certain things in trademark law that trademark specialists would take more or less for granted. I found them really strange, so I started wondering about it. And this is what I will then explain in a second as the problem we are discussing here during the talk. And then I will present several, what I call here balancing tools, you could say also potential solutions for the problem. And then the last part is definitely something where we should start discussing. The question is this a true problem, or is the problem solved? Can it be solved on the basis of the instruments that we have available in present legislation? So, what's the problem? Well, copyright law, and I cut a very long story very short here, but from a functional perspective, I think you could say copyright law is about cultural innovation. I don't like the term innovation too much in that context because it is in the cultural field, so let's say inspiration, in the sense that in copyright law we grant an exclusive right to persons who are able to create an original literary or artistic work on the basis of pre-existing material. This is something that is continuously confirmed by specialists from other disciplines, so whether you take people from art history or whatever, everybody is saying, well, there is no really new works of art, it's always based on pre-existing works. Which, from my perspective, makes copyright an inspiration system in the sense of a cyclic system. Yeah? So you take something from pre-existing works, you remodel, remix it, you come up with a new original creation, then you get copyright protection for a limited period of time, and then your work also enriches the public domain of cultural expression so that later generations of authors can take your work as a starting point for their creativity, and then the whole cycle starts anew. So that's copyright law. I could say the same about patent law. Basically, the same basic configuration. Somebody who takes the state of the art in a particular technical field and is capable of inventing something new on that basis gets, as a reward, as an incentive, a 20-year protection term, and after that, the patent, the invention falls in the public domain and can serve as a basis for follow-on innovation. The problem is that trademark law is a different story. So trademark law is not about this cyclic inspiration, cyclic innovation process. Trademark law is what I would call a transparency system. We want the market to be transparent. A trademark is a sign that is used exclusively by one particular enterprise to indicate the origin of the goods or services they are offering in the marketplace. And in order for the system to fulfill this function, we must ensure that the system is static, that this one enterprise can maintain the use as long as they are actively working on this product. So, practical example, you go to the supermarket and you buy Coca-Cola, you like it, and then you can rely on the trademark. When you go to the supermarket again, you want the same product because it has been satisfying. You just look at the label, at the logo, and you know for sure that when you buy Coca-Cola again, you get the same drink. And this is, of course, something we want to preserve. We don't want trademarks to fall in the public domain at some point. Because if we said trademark law is just for a period of 10 years, consumers would never know when the 10-year period is over. So at some point, you would enter the supermarket, you would buy the Coca-Cola drink and find out, oh, it's something completely different. And you would be dissatisfied with the product, wondering what the Coca-Cola company has done to it. And the reason is just that protection expired, but who would know? So trademark law has this different functionality. You want the system to be static. Once you have adopted a sign as your trademark, you can continue using the sign in trade and you get exclusive rights for that. So what is the problem now? Well, to give it to represent this graphically, if this is the basic functioning of trademark law and this is the basic functioning of copyright law, then you just see that the two are incompatible. Yeah? It's quite clear that static trademark protection, which is necessary for market transparency purposes, at some point comes into conflict with copyright law. And the point where this happens is, of course, when the two are combined. When with regards to the same intellectual creation, you have copyright protection and on top of that, trademark protection. So once you have this amalgam of the two, there's an interesting challenge for policymakers to ensure that the one is not becoming an obstacle to the other. And in terms of trademark copyright overlap, practically speaking, you would have to ensure that this static trademark protection is not becoming an obstacle to the cyclic inspiration innovation process in copyright law. Is that clear as a starting point? This is the starting point for the rest of my talk, so we should be on the same page at least on that common denominator. And then you may wonder, in the title I said Mickey Mouse and Mona Lisa. Well, first of all I thought, yeah, it must be a bit of a catchy title, not too technical. But there's also a reason for choosing those two. This problem comes in two different forms. The one is the Mickey Mouse problem, where you have something that is presently protected under copyright, and you have a copyright owner actively seeking trademark protection on top of that. This is something that you could say are the present marketing strategies. So when you look at Harry Potter, Star Wars, whatever is really popular, it's really mainstream cultural works, you will see that the copyright owner also seeks trademark protection for merchandising purposes and so on. So in many cases, cultural expression that is presently protected under copyright also has trademark protection on top of it. The same cannot be said about the Mona Lisa. The Mona Lisa has never enjoyed copyright protection because at the time there was no copyright in the sense of the modern statutes that we have. So is the Mona Lisa also a problem? You would say, well, strictly speaking, it is not a true copyright problem because it does not fall under copyright any longer. Functionally speaking, when you think about the problem, how I just explained it, the Mona Lisa, of course, is also a problem case because it is an important cultural material in the public domain, and we want this public domain to be free and open. So for our follow-on innovation process, we do not only want to ensure that present works that are in the cultural domain and enjoy copyright protection don't get trademark protection on top of that, we also want to ensure that the public domain that is freely available remains freely available, so that the public domain does not dry out. So these are the risks: drying out of sources of inspiration, or you could say monopolization of building blocks of potential new creations, and then, according to my approach, an impediment of the cultural inspiration cycle. You would also say this is kind of a functional approach. So if the function of copyright is ensuring this cyclic innovation, then trademark law could be a threat to it. I get carried away here. I expected this to be 5 minutes now, 15 minutes already. So let's move on a bit quicker. Balancing tools. I don't know if balancing tool is the right terminology, but let's use it for the time being. What could we do in order to solve this dilemma? Well, you could say we exclude signs that are culturally important from the outset. We just say, if it's potentially important for future cultural innovation, then we don't want to have this in trademark law at all. That could be one. Another approach could be, this would be the opposite approach. Well, we accept also cultural signs, but then we do some kind of rebalancing in terms of scope of protection. So the two extremes are you exclude signs from protection altogether, or you protect culturally important signs, but then with a limited scope, believing that the balancing can be done once they have been brought under the trademark protection regime. And there is some middle ground where you say, well, we need some fine-tuning, we need some gatekeeper requirements so that at the moment somebody asks for trademark protection, we can still decide whether or not we would accept a sign for protection or we would exclude it. And this, in trademark law, could be done through the requirement of distinctiveness, which is the basic requirement in trademark law. For a sign to attract trademark protection, it must be a distinctive sign capable of distinguishing goods or services of one undertaking from those of other undertakings. If you now feel that this is going too fast and you can't follow this so easily, don't worry. We are looking at those three types of solutions, balancing in more detail. So the first would be the exclusion from protection solution. I call this unconditional exclusion. So the argument would be the copyright innovation cycle, copyright inspiration cycle is so important, much more important than all these transparency values you may have in trademark law. Whatever happens, if a sign is culturally important, then we don't protect it under trademark law, no matter what. If you wanted to achieve this, which rules in trademark law could be used for that? Any ideas? So if you want to exclude something altogether from trademark protection?
It would have to be under the absolute ground of refusal. Something like the Mona Lisa would not be distinctive.
Yes, absolute ground for refusal. I like this as a starting point. The distinctiveness refusal ground is not the strongest, because once you show that it has become distinctive in the course of use in trade, this obstacle can be overcome. So if you look for the really strong exclusions, final word, you can't have trademark protection, whatever you do, what could that be? Well, I give you an example. I want to hear your view on that. I take the trademark directive in its present form, and then it says the following shall not be registered, or if registered shall be liable to be declared invalid. And then this applies to trademarks which are contrary to public policy or to accepted principles of morality. So the question is it immoral to register the Mona Lisa as a trademark? Is it immoral to register cultural heritage signs as a trademark? What would you say?
I think it depends who is trying to register. I mean, if the creator of a painting or Mickey Mouse is trying to register his own creation, probably less immoral, if at all, than if I try to register it.
Yes, so it might depend on who is asking for trademark protection. But let's say it's really cultural heritage. It's the crown jewels of the Queen, and somebody is taking a photograph of the crown jewels or a particular part of the crown jewels and saying, I'm registering this. How do you feel about that? National proud, I don't know, coming from the Netherlands, I don't know what national proud really is, but I mean, if somebody came and would say, well, orange, or, well, they have been attempts to register this anyway, so are you emotional about this? Or would you say, I'm so relaxed, I couldn't care less about cultural heritage?
Could you use the criteria on whether, given the trademark, enriches the culture from which the sign comes from? So say in the crown jewel example, if the trademark led to more revenue for Britain because it's culturally important for Britain, then it wouldn't be immoral to register it.
Oh, you mean when the registration generates some extra benefit? So okay, yeah. Well, this is an interesting argument from an economist perspective. Well, I mean, you can find economic analyses of IP law pointing in all directions. So whenever you start with economic analysis, you can be sure that you will find some argument pro and others contra. But there are economists arguing that actually the more trademark protection you allow, the more long-term investment in a sign you will ensure, because the trademark owner can just keep the sign. So in my Mickey Mouse example, if you take the trademark protection away, Walt Disney will have no more incentive to invest in the trademark because everybody can then use it after the expiry of copyright. By contrast, if you allow Walt Disney to keep the Mickey Mouse trademark, they will have a constant incentive to invest in the trademark. I don't know if you believe in the argument. I don't, but I don't want to influence you too much. I think it's a weak argument. But okay, I see. This public policy thing does not really fly here in this environment. Another one, trademarks which are of such a nature as to deceive the public. Would you say it can be deceiving when you register cultural heritage signs? But when we move it on to a particular type of deception, trademarks which have not been authorized by the competent authorities and are to be refused or invalidated pursuant to Article 6 ter of the Paris Convention. 6 ter of the Paris Convention is a particular provision for official signs and emblems that are excluded from trademark protection altogether. So standard examples would be flags, emblems of states or intergovernmental organizations. There are different approaches to the provision. There are different reasons advanced in order to explain why the provision is there. One of the lines of argument is that this is a particular type of preventing deceptive use. When you think of United Nations emblems, and of a country where somebody opens, let's say, a school using a United Nations emblem without being linked with the United Nations system in any way, then this would be deceptive, because the public would be misled into believing that there is a link between this school and, let's say, UNESCO. Yeah? So this is one way of explaining it. So this is something that could contribute to the solution of our problem, particularly when you look at 3.2 of the Trademark Directive, which says that while member states are free to extend this notion of official emblems being excluded from trademark protection even further. So not only 6 ter of the Paris Convention, but also official emblems that are not strictly falling under the international Paris Convention 6 ter rule. And there are member states that make use of this to broaden our thing. So instead of only state flags, they would also exclude on that basis flags and emblems of lower public entities. So this would be the flag of the city of Amsterdam, for example. And this lady here, I think I don't have to explain, she is not the queen any longer, but I thought she is still more charming than the king we now have in the Netherlands. So Queen Beatrix's photograph could also be excluded on that basis by saying, well, she is kind of an official figure, official emblem, official representation of the state. The Netherlands, I must say, does not use this provision in the Trademark Directive. So in that sense, these examples are bad examples, but particularly in the newer EU member states, so in the Eastern EU member states, you find countries making use of that provision, and then sometimes extending it also to national monuments. The next question then would be, is a famous painting a national monument? And when you take this extra step, then you are pretty close to an exclusion that could really make a difference. Like saying, okay, all important cultural heritage painting belonging to German culture, Czech culture, Hungarian culture, whatever, is a national emblem and falls under this exclusion. So this is just to illustrate that there is some room in trademark law to ensure that signs never fall under trademark law, that they are excluded altogether. If it is against morality, public order, or if it is deceptive, or deceptive in the sense of these 6 ter Paris Convention exclusions, then they are excluded altogether. Doesn't matter whether they acquire distinctiveness, whether they have distinctiveness, they would just fall outside the trademark system. But for our purposes and for our European trademark law, there is of course a much more interesting exclusion to be discussed, and these are the famous shape exclusions in the Trademark Directive. Well, there was a long debate on whether or not trademark law protection should be extended to so-called non-traditional types of marks. We know the traditional types of marks are words and figurative elements and colors added to it. So when you think of the Coca-Cola trademark, you do not only have the word mark, but you have the color breads, and you have a particular style, a particular font, and so on. This would be traditional. Non-traditional are new types of marks like shapes. And shapes can function as trademarks. When you think about the shape of the Bounty chocolate bar, for example, I think many people have an immediate association with a particular commercial source here looking at the shape. But when EU trademark law was further developed in that area, the legislator wanted to make sure that certain shapes remain outside, are excluded altogether. And these are those 3. Shapes resulting from the nature of the goods themselves, shapes necessary to obtain a technical result, shapes giving substantial value to the goods. You could say the explanation for excluding those is the fundamental distinction between the trademark and the product to which it is attached. The trademark should be something attached to the product, a badge of origin attached to the product. It shouldn't be the product itself. With shape trademarks, you get very, very close to product characteristics itself. So it made sense to introduce this additional safeguard saying, if a shape trademark gets too close to the product nature of the goods themselves, technical results, and potential value, then better to ensure that trademark protection cannot be acquired. There is standard standard case law on that, particularly in the area of exclusion of shapes that are technical functional. The leading case is the Phillips-Remington case about the shaver system. Phillips had developed this shape system with 3 razor blades rotating and so on. As far as I know, they had patent protection for this for 20 years. And then you must say, okay, if within those 20 years the shape did not become distinctive, then your marketing department really did a bad job. I mean, for 20 years you have been the only one with an entitlement to sell this particular product with those features. So if during 20 years of advertising and so on, you have not made sure that consumers, when seeing the shape, would immediately think, oh, this is Philips, then you should perhaps fire your marketing team altogether. Yeah? So after patent protection had expired, Philips thought, okay, now it has become a trademark, so let's continue protection, but then not under the patent law heading, but under trademark law. This has been litigation all over the world, basically, but all courts consistently held, at least the decisions I'm aware of, all held consistently that trademark protection is impossible because of the technical nature. The Court of Justice gave some core explanations for this. So first of all, no monopolization of decisive product features. This is safeguarding freedom of competition. So the idea was, by granting trademark rights for that, competitors would be disadvantaged because Philips could just continue having a monopoly on a particularly successful technical solution. So this would disadvantage competitors and would be against freedom of competition. And the second is, and this is more interesting for our purposes, that there should be no artificial extension of protection which the shape had already enjoyed under another IP protection regime that is limited in time. So no artificial extension of the term of patent protection, which is quite remarkable. So the court said, you cannot just combine whatever IP regime you like, which in terms of a private law approach is remarkable. I mean, in private law we tend to say, at least on the continent, I don't know about the UK, honestly speaking, some things are much different here in the UK, but at least on the continent, in private law, people would say, doesn't matter how many grounds you have for supporting your claim, you can combine all of them. So it can be contract, can be tort law, can be whatever, you just use whatever argument you have for supporting your claim. So from that perspective, it's a bit strange that the court says, yes, but you can't combine those two. Yeah? You had patent protection already, so you can't have trademark protection. Quite a remarkable step that was confirmed in another case, the Lego case. Similar, Lego had enjoyed patent protection for the functionality of the Lego brick. After the expiry of patent protection, they sought to maintain trademark protection. And here the court basically followed the same lines of argument, saying this would be anti-competitive and would be an artificial extension of patent protection that you enjoyed earlier. The case is interesting because the court also refused the so-called shape alternatives argument. Lego had, of course, said this is not anti-competitive because competitors can choose a different shape configuration. They don't need to use our functional specificities. They can come up with something different. But the court refused this. The court said this is not a question about alternatives. You just look at the shape as it is. And if the shape as such is dictated by functional technical considerations, then we exclude it from trademark law. Why does the Lego case also add to our understanding what happens here? What I find most interesting is that in the Lego decision, the referring court had explicitly stated that the Lego brick had become distinctive. And we all know that this is true. I mean, I can't think of my childhood without Lego. I loved Lego. I don't know about you. Is there anybody who hasn't played with Lego in his or her early days? So Lego is just iconic, you could say. So actually, and I still have this, when I see a toy brick, I immediately think Lego. Just works like this. So there is no way of denying that the Lego brick, in fact, is distinctive. Why am I emphasizing this? Well, it means that we are paying a price in terms of market transparency when we exclude the Lego brick from trademark protection. We say, even though people have this association, this strong link between the brick and the Lego company, we still say no. So to put it more strongly, we say we don't care about consumers being confused in this particular situation. We couldn't care less about the consumers. Consumers may be confused for a couple of months until they finally find out that it's no longer Lego in all cases, and then they will have understood this, and then they are no longer confused, but at least at the very beginning, there is confusion. Yeah? Suddenly it's no longer Lego exclusively, but also other brick producers. And you go to a toy shop, you buy bricks and you think it's Lego, and then you give it to a little child, and he or she says, oh, I'm so disappointed with this because it doesn't match the Lego bricks that I already have. I always was very disappointed when I got bricks that were not Lego, because they were just the bad guys in my Lego collection. You couldn't do anything with them. So it's really disappointing. So that's remarkable. In terms of policy, it means that we find the technical innovation cycle so important that we say this is overriding our transparency purposes. We accept confusion because the technical innovation is so tremendously important to us. So that's quite something as a statement. We move on to the juicy stuff. That was the trademark patent law overlap. What about trademarks industrial designs? Also a shape analysis. Industrial design can be 2D, 3D. We have old case law on the shape exclusions from, believe it or not, from the Netherlands, from the Benelux. And there was an old distinction drawn by the Benelux Court of Justice where they said, well, this shape exclusion, and this is not about functional technical shapes, this is about shapes adding substantial value to the goods. And there the Benelux courts would make a distinction between whether this substantial value is due to the inherent beauty or attractiveness of the shape as such, or whether the value is due to trademark recognition, that is the result of advertising and investment which the trademark owner did. If it's this one, the shape exclusion, substantial value shape exclusion, would not apply. Sounds a bit theoretical now, so I make it easier to digest for you. Let's say you are a jeans producer. Let's say you are G-Star. You know G-Star, the jeans? It's a Dutch producer. Well, G-Star basically conquered the market with some jeans that are really ugly. So looking at them from, let's say, a neutral design perspective, you would say, I've never seen jeans that are so ridiculous. I mean, it's really ugly. There's no reason why somebody would buy those jeans. What did they do? They started advertising campaigns explaining to particularly the younger age cohorts, no, it's not ugly. It's cool. Yeah? So you have to have those genes, otherwise you are not in. Yeah? So if you want to be really cool, you must make this statement, so you need the genes. Then this would become relevant. Yeah? You would say, is the value, the substantial value that is attached to the genes design, is that due to inherent beauty or attractiveness? No. It's really ugly from a design point of view. Is it because the trademark owner has convinced consumers that even though it is ugly, everybody needs to have it? Then you would be on that side, and then the shape exclusion, the substantial value exclusion would no longer apply. That was the traditional Benelux distinction. Why am I telling you this? Well, honestly, I'm getting older and older, and it's nostalgia. Because the Court of Justice had a case where we in the Benelux thought the court is crazy, they just didn't understand the questions put before it, but in the Benetton G-Star case, the court basically said, forget about this old distinction. It doesn't matter to us. Once the shape has acquired a substantial value, the shape exclusion applies. Whether the substantial value is due to inherent beauty and attractiveness, so whether it's really beautiful, or whether it has become beautiful in the perception of consumers because of successful advertising, we don't care. If substantial value is attached to the shape, then the exclusion applies. But from a Benelux perspective, we always thought the court just hasn't understood this, and we were waiting for further cases in order to confirm this craziness of the court. And there is one case I will get to in a second. But before that, I must show you another case, which was about inherent beauty and attractiveness, where the lower European court, so the General Court in 2011 said, this shape is adding substantial value to the goods, so here the exclusion also applies. And I guess it was judges having Bang & Olufsen equipment themselves. When you read this quote, indeed, the shape for which registration was sought reveals a very specific design, and the applicant itself admits that that design is an essential element of its branding and increases the appeal of the product at issue, that is to say, its value. And then the court goes on saying, furthermore, it is apparent that the aesthetic characteristics of that shape are emphasized first, and that the shape is perceived as a kind of, and now, quote, pure, slender, timeless sculpture for music reproduction, which makes it an important selling point. So this must have been judges who really loved this design. This is another policy question for us. I mean, you see how this substantial value shape exclusion works. What do you think? Is this a good policy decision? So reading this, you're basically saying, I exclude the shape from trademark protection altogether because it is so beautiful, because the designers have done such a great job. So what about our reward and incentive argument in intellectual property law? Are you rewarding great design in that way?
Not through trademark law.
Not through trademark law?
But probably you shouldn't.
Yes, but I mean this is one of the open questions. You had a comment as well.
I'm not just agreeing.
Yeah, I mean the counter argument from a policy perspective has always been, well, with this decision you are basically punishing beautiful design. The more beautiful the design, the lower your chances of getting trademark protection. So instead, if you really want to have trademark protection, the design should be so-so. I mean, distinctive enough to become a source identifier, but not too beautiful, not too strong. Otherwise, trademark protection would be excluded altogether. But yes?
How do you know whether it's inherent or created beauty?
Oh, okay.
It seems like an odd distinction to make. I mean, it seems like like actually not a
Yeah.
distinction. Like what if a manufacturer, I mean I can see like the case where the manufacturer really does a huge advertising campaign, you think, oh, they've sort of maybe created it. But let's say they've just taken advantage, let's say they've done a lot of research and actually realized that people have some strange heuristic where they respond in a certain way. They don't have to do any advertising to make it work, but they then, use that design and it has the same effect as the marketing campaign. The latter would maybe appear to be more natural because it wasn't, created through advertising.
Yeah.
Yet it's essentially no different. It's just using a different mechanism.
Yeah. Well, what can I say? I'm a lawyer. It depends. I mean, this is really one of the areas where you would say, interdisciplinary research or something could make sense, but how to frame this, how to arrive at a better understanding of what aesthetics really is and what really matters for the purchase decision of consumers, this is something that has not been explored in sufficient detail. There are some studies, but I think I look at Lionel. I'm not aware on studies that really convincingly, with sufficient empirical evidence, would demonstrate what really matters. So what really is substantial value. There are many people saying that the whole concept is flawed. But
Couldn't you also say that Bang & Olufsen got themselves in a corner? Because aren't they saying everyone loves our stuff because it looks like a timeless sculpture?
yeah,
So they're saying what attracts people is the shape of, and it's the sculpture.
yeah.
So in a sense, it's almost their fault that they
Yeah,
lost.
they had bad lawyers, obviously.
Yeah.
They should have asked us. I mean, no, that's true. Perhaps the way they argued the case was not the most sensible way of doing that.
So why do they want trademark protection? This is a new design. They can get design protection.
Yes. I mean, I fully agree with that.
Well, for 25 years, I think people won't be buying
And that
those.
will be not be selling in 25 years this stuff anymore. No one will buy this.
Yeah.
I don't think there's a need for trademark to have any incentive mechanism or function in that area at all.
Well, the point is, at least from a Dutch perspective, it's not only the 25 years, term of protection in industrial designs law is 25 years, but from a Dutch perspective, you would, of course, have copyright protection as well. So you would have life of the designer plus 70 years. So this is quite generous. So why do you need trademark protection then at all? Criticizing the doctrine and agreeing with you that the whole concept is very unclear does not do any harm to my argument. Yeah? For my general argument that we really have to be careful here, this just adds a further layer. We have seen that we are very careful in the area of technical functional shapes, and it seems that when it comes to industrial design, the court is also prepared to take a broad approach, saying we don't care about this old Benelux distinction. The moment the shape has substantial value, that's good enough for us, and we exclude it from trademark protection altogether. There's a further case that I have to mention in passing at least. It's this year's Stocker case. This is ongoing litigation, not only in the Netherlands, also in other countries. And the lawyers doing this are so lucky. I mean, for years now, I guess, they are running their business on the Stocker cases. In the Netherlands, it's not only this case that went all the way up to the Court of Justice. There are several other cases pending. Stocker, and then the competitor in the Netherlands is Hauk, coming up with similar chair design, and they are fighting each other on the basis of copyright, industrial design protection, trademark protection, whatever. So now we have this decision of the Court of Justice. Many colleagues say, we don't understand this decision at all, it's so unpredictable. I find, in the light of what I've just shown, this G-star and Bang & Olufsen thing, I find the decision is not surprising. First of all, the Court of Justice confirms the basic rationales underlying shape exclusions, two things: competition on the one hand, no artificial term extension, no evergreening, of rights with limited period of protection on the other hand, then the court says with regard to the shapes resulting from the nature of the goods, we apply this broadly. This applies not only when a shape is indispensable for the goods, like the natural shape of the goods or a regulated shape that has to follow certain standards, but also when the shape is inherent to the generic function. So I see this as a further step in broadening the scope of the shape exclusion. And then when we get to the substantial value exclusion, something which also played a role in the G-star decision and which played a role in the Bang & Olufsen decision, the court now comes up with a whole catalogue of criteria which may add, hopefully, some clarity with regard to your question. The court says, well, this concerns all types of essential characteristics that determine the value that is attached to the shape, can be nature of the category of goods concerned, can be artistic value, this would be the Bang & Olufsen thing, dissimilarity from other shapes on the market, so can be outstanding, pioneering design, substantial price difference, and then the last thing, this is, as far as I see it, a reference to the G-star decision, promotion strategy accentuating aesthetic characteristics. So clearly the court now said this old Benelux distinction is really dead. Forget about it. So if you and Benelux thought that in G-star we haven't fully understood the question that you put before us, then you are wrong. We really don't want this distinction that you have drawn. So even if a shape has become has acquired substantial value because of your marketing efforts, then it still has this substantial value, so it still is excluded from protection. So I must admit, I don't find this very clear, but I find it understandable that the court comes up with this list, this factor analysis, in the light of the decisions that I have just shown. And as I said, for my argument, this doesn't really matter, because it's quite clear that the court is prepared to apply those exclusions in a rather broad, flexible manner. Which brings me finally, we have now had the trademark patent overlap, the trademark industrial design overlap. So what about the literary and artistic works overlap, the copyright overlap? What about those two guys? They are not technical, they are not functional, and at least as drawings, they are not shapes. So, in many national systems, we are relaxed about this. Copyright protection is limited in time. Do we really care, or do we say a term extension by a trademark law is possible? And the answer in many national systems is yes, accumulation of rights is possible. So you can have that. You can have copyright protection for Mickey Mouse, and once this protection expires, you just continue with trademark protection. And the question then is, should something be done about it? What is your view? We have seen that the exclusion comes at a cost. We have seen that in the area of the technical functional shape exclusions, the Lego brick. Once you exclude it from protection, consumers will be confused, at least for a while, until they have understood that it's not all Lego on the market. And now my question is, why can't we do the same for those two guys? I think Mickey Mouse copyright will expire in a couple of years. I don't know exactly, I think 2017 or 2020, this should expire. And then I would say, who cares? I mean, consumers will be confused for a while. And then after 3 months, perhaps half a year, you understand that Mickey Mouse is used more broadly also by other people, not only by Walt Disney. So why is this so difficult? I'm saying this, but I mean, in terms of trademark philosophy, you must say that people now think the whole trademark system crumbles into dust, basically. mean, one of the core rationales in trademark law, one of the mantras is we need trademark law in order to ensure that consumers are not confused. So saying that in some instances you don't find this so unreasonable, it's like saying you are raising the specter of trademark law with one of the basic principles being abolished altogether. Still, I'm wondering, I mean, if we don't have difficulty with the Lego brick, which is iconic for the Lego company, why should we have difficulty for those two guys? Any views on that?
So is it all literary and artistic works?
Sorry?
Would you apply and formulate your exclusion to cover all literary and artistic works?
Yeah, well.
Once copyright has lapsed? Or would you confine it to some narrow subcategory that had acquired some intrinsic value of their own so as to fulfill the competitive need function identified in the case law?
Well, I would say if you wanted to include this in trademark law, you would need a rule comparable to the shape exclusions that offer these fine-tuning possibilities. I'm not saying that the court has been very successful in applying the shape exclusions, but on the other hand, not everything that falls under copyright would have this cultural value that I seek to preserve. So rather than, well, competition and this artificial extension, now evergreening rationale, that would be two, but in terms of literary artistic works, according to my approach, you would have to add the cultural value question, which is a very difficult one.
And,
Very, very difficult.
so one thing would also be question the extent to which you could sort of have a more relaxed view on use on in the course of trade.
Yeah.
So say, I mean, if you say Mickey comes in the public domain, obviously that only refers to a particular drawing made at a particular point in time. Anything drawn later by other sort of authors commissioned by Disney, obviously that's not in the public domain. A Mickey Mouse drawing made last year, commissioned by Disney, will not be in the public domain, but only 70 years after the death of the person who has drawn it, right?
Yeah.
So it's only that maybe the Steamboat Willie kind of cartoon from whatever then when that was made comes into the public domain. And then if you use that for a non-trademark purpose, so not to indicate origin, simply to describe things or to refer to things or to, you know, make a statement about a particular cultural thing, well, that's fine.
Yeah, but still, I think we would still win a bit of freedom, because I mean, this is the drawing as such. What you are referring to, these more recent drawings, they would enjoy copyright protection in the particular setting. So a Japanese manga producer would still be free to redefine Mickey Mouse as a bad manga hero and drawing its own story of Mickey Mouse. So that would, I mean, with trade.
Would that be used in the course of trade? Would that actually be sort of using Mickey Mouse? If someone sort of makes a caricature of it, would that actually amount to a trademark infringement if you apply the ordinary analysis? If you take a sort of more relaxed view on use on the course of trade, or say, well, it's probably descriptive, you know, it's whatever. It's and what is it? Not in without due cause, as the directive says.
Yeah. Well, I mean, years ago I would have said, yes, perhaps this is not relevant use in the sense of trademark law at all, because it wouldn't be seen as an indication of commercial origin. But this basic trademark use requirement has been diluted and lowered down to such an extent that nowadays the Court of Justice says establishing a link between the conflicting sign and the goods and the product is already sufficient, which brings me to a solution later in the infringement analysis. So you would in fact need this due cause defense. And of course you can solve these cases on the basis of the due cause defense, but at a much later stage, which means after the Supreme Court in a country and the Court of Justice and so on has ruled on it. And if I am a designer and I don't have much money and I have the powerful Walt Disney Company on the other hand, this can have quite a deterrent effect on your productivity, on your production. In the sense that perhaps you would do something else. You would say, okay, rather than running this risk, I just invent some new character. But you are not as free as you would be with expiry of copyright. I mean, expiry of copyright just means public domain. Do as you wish.
Can I just ask a question about Mickey Mouse? I mean, is there a trademark in that particular picture of Mickey Mouse, or is it just the name Mickey Mouse that is a trademark?
I took those, as far as I remember, from the international Madrid registration, which Walt Disney did for the two, Mickey Mouse and Donald Duck. So they are registered for quite an extensive list of goods and services, but I think they are well-known trademarks anyway. So the list.
So would the argument be that any other way that you depict Mickey Mouse would infringe that trademark? Do you think that's what they would argue?
And they would argue that using the word.
Well, that's a different thing. Yeah, the words itself. But yeah.
But, I mean, it's not only
using the word infringes the visual.
Oh right. Yeah.
Well, I think it has an impact because trademark law is not only identity but also similarity of signs. So.
Yeah.
Just on your comment about Lego, it does seem as Lego is a bit different insofar as you always buy Legos in a box, so they're going to have the name Lego written on them.
Yeah.
So the customer confusion doesn't seem nearly as worrying. It doesn't seem like customers would really be worried at all. They know they're buying Lego because it says Lego on the box, whereas here it's not as. I mean, the argument for confusion seems stronger insofar as Disney would have to start writing Disney's Mickey Mouse on everything, which sort of is currently not the practice, right? So if a consumer wanted to know they were getting Disney's Mickey Mouse instead of somebody else's, right?
Yeah, but you might get more sophisticated consumers. I mean, in the past, when buying toy bricks, I just assumed that they would be Lego. Now I take a closer look and I check is the Lego trademark attached to it. The same might happen with Mickey Mouse. I mean, if you know after expiry of IP protection altogether, you buy a Mickey Mouse book, then you would perhaps check, is Walt Disney somewhere, is the Disney trademark somewhere on the book. So you would just look for other distinctive elements, I guess. It is a step of consumer education and sophistication that has to be taken, but I think it's doable. Well, I'm more afraid about another argument, but at least I have been thinking about that argument for quite a long while. That's the substitutability argument. People looking at the area of literary and artistic production from somewhat general perspective are saying, well, this is subjective. It's the area of subjectivity. If you don't have a particular cultural material available for your follow-on production, you just pick something else. If you don't have the Mona Lisa available, if you don't have Mickey Mouse available, then you just invent around it and you end up with another wonderful artistic creation because there is so much still available, so it is so subjective. And this could be a major difference that you say, well, the technical domain is objective. So there is one technical solution and perhaps 5 or 6 alternatives, but inventing around one particular technical solution is much more difficult. So what do you think about this substitutability argument?
Well, part of the case for protection of Lego is that you must be able to buy things that will work with what you've got already.
Yeah.
and there was litigation here as well, of course, and it all had to do with minute sub-millimeter differences between the Lego product and the imitations.
Yeah.
And that becomes relatively concrete and maybe a reason for going further.
Yeah.
When that kind of element is there, that kind of substitutability.
Yeah.
But there's not the same in relation to Mickey Mouse, is it?
Yeah. So you would say there is
I
this.
don't want him in exactly this position and that position only.
Yeah. So you would say there is something, there is this difference in terms of substitutability. Definitely. Is this difference big enough to justify saying, well, when it comes to copyright, trademark overlaps, we don't have to care to the same extent? Yes, please.
There's an analogy though between cultural output and technical solutions that there might not be substitutability. I mean, Marcel Duchamp's famous parody of the Mona Lisa couldn't be done with another painting, or not done as effectively with another painting.
Yeah.
In Australian copyright law, which is what I'm familiar with a little bit, there's a parody and satire, statutory parody and satire exception. I don't believe there's an analogous exception for trademark infringement.
Yeah.
So I think this isn't a particularly. In certain circumstances, you can see where the cultural property has to be the original source material.
Yeah.
Does a critique of American capitalism using a slightly different mouse, cartoon mouse, work as effectively? Probably not.
Yeah. Yeah. Further. Well, actually, I should have given this presentation years ago. I should have listened to you at the time, because it really took me quite a long time until I found what I think is a convincing answer to that argument. But first of all, you can develop a legal argument. You can say, well, this alternative question has already been decided in the Lego case, and the court said with regard to technical shapes, it doesn't matter whether they are alternatives. Then it doesn't matter how many alternatives are there. So that could be one. With regard to the economic argument that I said, well, Disney would not invest any longer in the drawing if trademark protection was not offered, and they would lose copyright protection. I think I wouldn't buy that argument. If they have to face competition suddenly, they are first of all in a good position anyway, because they had a monopoly for quite a long time, so they are strong in the market anyway. So they will run even harder when they are exposed to competition, to the rigors of competition. So I don't buy this economic argument, but this substitutability argument has always remained a true concern. And when you have started writing something, and I'm writing a book about it, so when you have started writing something and at some point you are confronted with an argument where you think, okay, perhaps I must forget about the whole story I wanted to tell, then you're really relieved when you finally find something that helps you argue your case. And I found, and this is basically what you were saying, when you look at a sociological analysis of the field of literary and artistic production, and I refer to Pierre Bourdieu here, he is saying, in the case of avant-garde productions, the constant evolution of new avant-garde movements depends on freedom of the next generation to criticize pre-existing works. So the freedom that is there for coming up with a new avant-garde step in the development of the arts depends on the gaps in the texture of literary artistic works that are still available for autonomous avant-garde artists. Which means that the moment you take certain bits and pieces of this texture away, the avant-garde's next step will just not happen. And you never know which part of the texture is decisive. So you cannot just take away whatever you like, because the one piece that you have taken away, you take away the Mona Lisa, for example, then you may not see a whole avant-garde movement developing. So the argument would be that at the consumption level, the substitutability argument is perhaps true. If you see a concert program and they tell you, well, we can't play this particular symphony any longer because it is trademarked, then you say, okay, I don't care too much, just play another symphony. There are so many symphonies out there. So at the consumption level, this may still work. You may have the same enjoyment with different kind of cultural work. At the production level, it really makes a difference whether cultural productions are still freely available or not. I'm not saying that this is revolutionary that I found, but I was happy to have some theoretical basis for this. So thanks to Pierre Bourdieu. And one of the examples he is giving is indeed this art like Andy Warhol, who uses the Venus and then puts it in a pop art painting and so on, which is clearly an appropriation of something that has been there in the cultural history. Yes?
Yeah, I was going to say Andy Warhol, because he also appropriated the Campbell soup can, didn't he?
Yeah.
So would you say that also should, if that had, which it did have trademark protection,
Yeah.
did that impoverish the avant-garde?
Well, actually, this is one of the final parts of the book that I'm drafting, and there I ask, perhaps we are all wrong in our perception of the importance of the different IP fields. So if it is right that trademark law is a structurally weaker type of IP, then we would have to say that trademark protection should end if the trademark becomes culturally important.
Yeah,
I'm not sure if I really will take to those extremes, because otherwise the whole thing may be seen as becoming ridiculous. But I think at least, I mean, I would have to point out that if you take it to the extremes, if you draw the last conclusion, then this would be one of the conclusions that you say, well, this reasoning would also justify ending trademark protection at some point when the trademark has become so iconic that it has an important cultural value, which is bad news for Coca-Cola, for example, according to that approach.
That's essentially an extended version of genericness, isn't it?
Yeah, yeah, cultural genericness. I think, looking at the time, I leave it at that, or I cut the rest of my story very short, because I had announced that we look at different balancing possibilities. So this was just the most radical one. Yeah? Like, can we solve the problem by excluding cultural subject matter from protection altogether? There is a better or a more flexible way of doing it by saying these cultural signs are just not distinctive. The problem, well, I have lots of sheets of that, but I just tell you the core things. We have this distinctiveness requirement becoming relevant for generic, descriptive, non-distinctive signs, but it can be overcome. You can acquire distinctive character through use. So this makes it an unreliable solution for the problem. Which means, when we turn to cultural heritage, if the Mona Lisa is not seen as being distinctive from the very beginning and is denied registration for that reason, then you could overcome this denial of protection by making advertising and telling consumers the Mona Lisa refers to our company. The Mona Lisa is a sign that we use exclusively for our goods and products, and once consumers have understood this, you could finally get it registered. There is some support for this. There has been a decision in Germany on the Mona Lisa where the court solved the problem on the basis of the Mona Lisa not being distinctive and the Mona Lisa being used so often in a commercial context, in an advertising context, that it has become customary in trade. I would say fair enough for the Mona Lisa, but
for what goods or services? Customary.
I don't know the check. I don't remember.
Jigsaw puzzles?
Yeah, well,
For everything.
I mean, in terms of practical solution, like saving the Mona Lisa from trademark protection, I understand the reasoning, but it's weak. Because the company could just invest heavily in advertising. Having said that, there is this paper by Defgang Ji saying that it's not this one line, like when you say trademark proprietors can do whatever they want with the perception of consumers, that doesn't seem to be 100% valid, at least when you ask marketing specialists. But what would they say? I mean, if they said, yes, we can do whatever we want with consumer perception, then it wouldn't be an art any longer. So, why I'm wondering about this, well, think about this famous painting being registered for weapons. It's distinctive. I mean, it has never been used for weapons before. So I would say, if you take a small little part of this Picasso painting, a statement against war, a statement against the civil war in Spain, if you take a little distinctive part of it and you say, I registered this for weapons, how could an office refuse that? Or think of melodies. Years ago, Licher Beer, a German beer producer, used one of the melodies from Peer Gynt for Licher advertising. People were going to music stores saying, oh, I heard this wonderful melody, what is it? Yeah? So suddenly Peer Gynt and so on became famous because of the advertising, but it has become distinctive. I mean, people were establishing the link between the advertising and the melody. So I have doubts about the effectiveness of this distinctiveness criterion, and I have some more slides on this. Then third solution, can't we solve the problem within trademark law? So can't we say, if things really go wrong and protection is acquired, is that really a problem? Or can't we do the balancing within the system? And then there are certain considerations here. You say, well, first of all, there is the principle of speciality, trademark protection only relating to specific goods or services, so relevant goods or services could fall outside the trademark protection altogether. You could say we do the filtering with the trademark use requirement. We say if the use is not seen as a source identifying use, then it falls outside the trademark system altogether. Or we could do the balancing in the area of protection of well-known marks by applying a very strong standard of well-known mark. I can tell you, yes, you could do so, but the development of trademark law in recent years has been in the opposite direction. So what the Court of Justice in Europe has done is lowering the threshold for the general trademark use requirement, lowering the threshold for assuming that a sign is well known. So, yeah, even though you could do this, I think we can't be relaxed here, and we have to admit that these threshold requirements have lost lots of its power. Also, quite some sheets here, but I'm happy to give you the presentation and then you can share it with the group if somebody wants to consult it. So is the problem solved? I think no. Otherwise it would be worth spending time on it. I think we should go for cultural grounds of refusal to prevent the risks that come along with overlaps in the area of copyright trademark protection being combined. With that, I won't hold you any longer. Thank you so much for listening. I hope this is some food for thought. And for those who are considering specializing in IP, I hope this is an extra incentive for acquiring more knowledge in that field. It's big fun, I can tell you. And I know that here in Cambridge you get a very good education in IP, so go for it. Thank you so much.